So, kia ora hui mai tātou, he mihi ana ki a koutou, nau mai haere mai ki tēnei hui ngā ture ipurangi o Aotearoa, our members webinar. Nō reira nau mai haere mai whakatau mai. Today, author of Telecommunications Law in New Zealand, Robert Clarke, that's him, will discuss the regulation and non-regulation of ISPs, over-the-top suppliers and end users of these services in Aotearoa. We'll have a Q&A at the end of the session. We won't be looking at the Zoom chat actively throughout, but there's a Q&A function that you can use, and I'll be checking those from about 12:30 when we get into questions. Now, before Robert kicks off, I want to remind everyone here that we've got a code of conduct that applies to all InternetNZ events, online and offline. We have 4 pillars in the code of conduct, and they're pretty simple. Respect people, enable participation, stay on topic, and keep it safe. And that helps us all to have a good conversation. I think Vanessa is going to put that in the chat, so you can have a look at it there. There's also a link that will go through to our website. All right, so if you've got burning questions, again, feel free to put them in the Q&A, and let's kick off and hear about internet law in Aotearoa. Over to you, Robert.
Thank you, James. Hello, everybody. My name's Robert, as James mentioned. Some of you may remember me from time you've spent at MB, either working there or dealing with us. I'm still at MB, but not so much in the telco or internet space these days, which is one of the reasons I feel and am able to talk to you today, and I'm doing so in a personal capacity. I'll just give me a second while I call up my presentation. Now, is that presentation? Here we go. I apologize.
Looking good, Robert.
Terrific. Thank you for that encouragement, James. I'm a newbie for these webinars. I'm more in the same room kind of person, but given the topic, I should really get to do these things more often and better. So internet law in Aotearoa, ngā ture ipurangi o Aotearoa. Thank you for joining me. I'm going to tell you a bit about the structure of today's webinar. When I'm following a presentation, I do like to know what the structure is so that I have a few signposts. Firstly, I'm going to talk a bit about me, let you know who I am, what I've done, and why I'm qualified to be talking to you today. Secondly, I'm going to be talking to you about the main players in terms of internet law, not so much the institutional players like the Minister or perhaps the Commerce Commission, but more the market players. And just a spoiler alert, those 3 market players are the last 3 sections of the presentation today. We have ISPs, so the likes of Spark, over-the-top providers, the likes of Facebook, and then we have end users, which is you and me. And before I do kick off, I just wanted to highlight 2 things about ISPs and over-the-top providers in terms of what I'll be talking about. Firstly, I'll be talking about what we regulate here in New Zealand. And as a way of putting all that in context, I'm also going to be talking about what we don't regulate. So that will involve looking at some other countries, seeing where they regulate, where perhaps we don't. And what that'll do is really help us understand if we're a heavily regulated country in this respect, a lightly regulated country, or something in between. There's one other thing I'd like to point out today. If you can see, there's an arrow pointing to a slide number, and this is another technique to ensure that people can know where exactly we all are in this presentation. We're currently at slide 2, and there will be 13 slides. So brace yourself for another 11. So a bit about me. Here's my career history. I was originally a lawyer. Spent a lot of time actually in sub-Saharan Africa. This was the late 90s, early 2000s when the World Bank was making rather large loans to developing countries. And in return for those loans, the countries concerned had to open up their utility sectors to competition. And of course, when you do that, you're going to need laws to govern the market players. And I was involved in that in places like Rwanda and Tanzania. It was a fascinating time. I then moved to become a lobbyist for a mobile operator. I spent much of my time in that capacity traveling to Brussels to convince the bureaucrats there that our mobile roaming fees were completely justifiable, a battle which we lost. Then I came home to New Zealand and I became a ministry official. I joined initially the telecommunications team, then I moved to the radio spectrum team. But since then I have joined the heady heights of the corporate governance team. So I'm no longer involved in telecommunications matters officially. So as I mentioned before today, I'm speaking in a purely personal capacity. So this second part of the presentation really is just to give you an overview of the main players. First ones, as I mentioned, are the ISPs. Now, I've just brought up a something resembling a circle on the screen, and this is because when I was preparing for this presentation, I was also finishing off a couple of books. One's called Sapiens by a chap called Harari. Another one's called Guns, Germs, and Steel by Jared Diamond. And they spent a lot of time talking about the different kinds of humans that there have been. And I thought, well, that could be a useful way of describing ISPs and who they are and who they aren't. So rather than our genus, though, being humans, our genus is network operators. And ISPs are one type of network operator. And another type of network operator is what we might call telcos. ISPs are the Homo sapiens in this picture, and the telcos are the Homo neanderthalensis, or Neanderthals. A couple of examples of ISPs, pure ISPs, Gisborne.net and Wiz Wireless. Gisborne's up on the East Coast, Gisborne.net. Wiz Wireless is in the Wairarapa, and they are WISPs, so the name gives it away. They're wireless ISPs. Telcos, there aren't too many pure telcos left. One I thought of was Team Talk, which has actually been bought by Vital in the last couple of years. So I'm not sure if it's a perfect example, but the main names that you'll all be familiar with, they're actually both ISPs and telcos. Companies like Spark and Trustpower, when they're providing you a connection to the internet, they're acting as ISPs and they'll be regulated accordingly. And when they're providing you with the ability to phone somebody on a telephone number or send them an SMS, they're acting as telcos. So we'll get rid of our pictures down here so we can fit in a bit more of a description of what telcos and ISPs are, and you'll see the difference between the two. So for those of you who are of a technical mind, telcos, they can use packet switch networks like VDSL or 4G, but like good Neanderthals, they're still trailing around with a couple of circuit switch networks. So the PSTN in the fixed context, although that's being phased out. And in the mobile context, you've got some 2G networks. Now, ISPs are different. They only use packet switch networks. Another difference, telcos, they tend to sign interconnection agreements in the sense of terminating one another's calls or SMSs. And ISPs, they tend to sign transit agreements, or if they're pretty big, they sign pairing agreements. And then this last difference, which I think is perhaps the largest, the most important for our purposes, is that telcos, they provide the carriage, that is to say the transport of your communication, but they also provide the application, that is to say the means of accessing that carriage. So a voice service, an SMS service, or a fax service. So fax and SMS would be over a circuit switch network. A voice service, that might be over either over a packet switch network, for example, it would be voice over broadband or voice over LTE. And over a circuit switch network, it would be the good old-fashioned POTS. Now, ISPs, they only provide carriage. And so if you want to use an ISP, you actually have to rely on third-party applications, things like Skype and Gmail. So I just wanted to give you that sense of how you can put ISPs in a broader context. Some are pure ISPs and some are hybrids, really. Spark, Trustpower, Vodafone 2 Degrees, who retain that telco element, but also act as ISPs. Now, there's an arrow here pointing to third-party applications, and that is where our over-the-top providers come in, because over-the-top providers are the parties that provide those third-party applications. So you've got Google, who provides Gmail and the Google web browser, search engine, I apologize. Netflix provides a Netflix app, which is on my smart television. And Skype Technologies provides the Skype app, which I use to call friends in the UK. And lastly, we've got end users. End users can be end users of the third-party applications or end users of the applications that are managed by the telcos themselves. And we're, for the purposes of this presentation, interested in the end users of third-party applications. We're not so interested in the users of the managed applications. So I'd just like to get cracking now. Oh, but before I do, I seem to have put a picture of a stream in here. Now this is perhaps part of my pedagogical bent, but there is an expression that you'll hear often in the regulatory world, which is upstream and downstream. And I thought I should put it in here just so that we know which of these market players is upstream or downstream from the other, just in case you come across this. ISPs are at the top of the stream, so they are considered to be upstream of over-the-top providers. Over-the-top providers are in the middle of the stream, so they're upstream of end users, and end users are at the bottom, that is to say downstream of everyone else. So let's get cracking and look at these three main players one by one, and how we regulate them in New Zealand and how we don't. End users, over-the-top providers and ISPs. I thought about how to explain how we regulate these things, and it seemed to me that an analogy would be a good idea. So end users, here they are. at the bottom of the stream. Oh, beg your pardon. Over-the-top providers, midstream, ISPs, right upstream at the top of the stream. Our analogy that we're going to use is courier service. So I want you to imagine that you're trying to send, say, a book from your place in lockdown to somebody else in the same city. What you do is you give that book to somebody who packs it and then puts it in a van. And that van packer is, in our analogy, the equivalent of the over-the-top provider. The van packer then gives it to the person who runs the van, who is the equivalent of our ISP. So the ISP drives its van to the destination. The van is then unpacked by a representative of the van packer, that is to say our over-the-top provider, who then unpacks it and sends it to the destination. So using this analogy, we can try and understand some of the concepts of how we regulate these different market players. So in terms of regulating the party that drives the van, the ISP, a couple of terms you might hear are net neutrality and deep packet inspection. So using this analogy, net neutrality would be, can the van company, can it discriminate between van packers? Can it give certain van packers access to the fastest bands or to most space in a given van? That's the issue of net neutrality. Deep packet inspection, in our analogy, that's, can the company that drives the vans pull over and open up one of those packets and see what's in it? Then if we use the analogy in terms of the van packer and its relationship with you and me, some of the terms we might see are things like platform neutrality, which is effectively the equivalent of the net neutrality issue that we just saw before, but in the relationship between the over-the-top provider, the van packer, and the end user. So can, for example, a van packer who has a relationship with an end user give that end user a preferential access to his or her services? Can they work faster for that person? And can they actually block some people and refuse to pack their parcels into vans? Data portability. If an end user is using one van packer and has been for a while, can they ask that van packer to transfer all the useful data that they've given to them over to another competing van packer? Labeling. Does the van packer have to label those packages so that the person who's receiving them knows what to expect? And local content is another issue you might hear here. Does the van packer have to make sure that, say, 30% of all the packages in the van that it's packing are New Zealand made, so to speak? Those are the regulatory issues at that level. In terms of end users, it's really about the regulation between them. For example, one end user might send offensive communications to another. Another might send or post harmful digital communications. Another might send spam. Another might distribute an objectionable publication. So that's really an analogy which I like to use, which can really make it more concrete what we're trying to discuss when we talk about regulating these different market players. I'm going to focus first on the ISPs and talk about what we regulate. Here's our picture from earlier where we were talking about ISPs and how they differ from telcos. In as much as they're network operators, ISPs will qualify as they will qualify as network operators, I mean to say, and so they'll be subject to obligations under the Telco Act and the Telecommunications Interception Capability and Security Act. That means an ISP in its capacity as a network operator is going to have to pay the Telecommunications Development Levy, which used to be about 50 million a year, and it was divided up between market participants. It's now down to about 10 million per year. They're also going to have to assist security services, the GCSB and the SAS with, the GCSB with interception requests. But what I'm interested in is what are the obligations we have in New Zealand that are specific to ISPs themselves and that telcos, for example, won't necessarily share. The main one that I've come across is the 3 strikes notification. So you might remember a long time ago, there was a thing called file sharing, and it caused a lot of consternation amongst the content industry. Well, there's a sub group of ISPs called IPAPs who have obligations under the Copyright Act 1994 when a content owner discovers copyright infringement on the internet, then the IPAP will have to send a detection notice, then a warning notice, then an enforcement notice, and at that point, the content owner can go to the Copyright Tribunal to try to get damages. IPAPs are really essentially just fixed ISPs because the mobile ISPs manage to gain an exclusion. And this obligation doesn't really amount to much these days because file sharing has really been left behind by streaming. And I don't think there's been an application to the Copyright Tribunal since about 2015. So that's how we regulate ISPs themselves. We impose that obligation. The other regulation we have isn't obligations so much as safe harbors. The safe harbors are 3 in the Copyright Act. If a user or an ISP infringes copyright, then 96B of the Copyright Act says merely because that user is infringing copyright, that is not enough to mean that the ISP is a party to it. You might remember global mode. I was quite excited when I came back to New Zealand and global mode was released. This was essentially, I was with Slingshot at the time, and what it meant was that they automatically turned on a VPN for you so that it would appear to the Americans that I was actually dialing in, if you like, from an American address. There was a bit of debate about whether Slingshot and the others who were doing this would be able to benefit from that safe harbor because they weren't merely providing transmission services to the internet. They were actually, in a sense, facilitating copyright infringement, but we never got a court decision on that. Other safe harbors, Crimes Act, it's an offence to publish an intimate visual recording, but under 216K, that doesn't apply if you're just providing the means of transmission. And same again with spam. Under section 16 of the Unsolicited Electronic Messages Act, you're not a party to that spam just because you provide a transmission service that enables spam to be sent. I think now I really want to look quickly at what we don't regulate in terms of ISPs. One thing we don't regulate in New Zealand is net neutrality. And that's when an ISP provides an advantage to one over-the-top provider or imposes a disadvantage. So the advantages could be prioritizing its traffic or zero rating its traffic. The disadvantages could be throttling or even blocking it. That's unlike the EU, which has a ban on any use of prioritization or zero rating. And I've also put the USA here, but I've put them in orange because it's a bit of a political issue. Back in 2018, their FCC, their regulator, introduced the Restoring Internet Freedom order, which even though it removed most of the net neutrality rules of the previous FCC order, it did still retain some obligations on ISPs to be transparent about what they were doing. And so in that regard, even the USA has more net neutrality rules than New Zealand does. And here's just a recent example of ISPs, in this case, mobile ISPs, getting in trouble for violating net neutrality rules. ISPs, what we don't block, what we don't regulate too is website blocking. We don't force ISPs to block websites. Australia and Singapore do. So Australia has a Copyright Act provision which enables a court to order an ISP to block a site that's principally designed to facilitate copyright infringement. I think movies 1, 2, 3 might be the type of thing they're aiming at. Singapore goes even further. They have a law called the Protection from Online Falsehoods and Manipulation Act, 2019, and that really enables the relevant minister to order an ISP to block any old website that has a statement that the minister does not consider to be factual. And they used that recently to block a website in Malaysia run by Lawyers for Liberty. What we also don't regulate in New Zealand is we don't have a ban on deep packet inspection. We have privacy laws which may constrain deep packet inspection, but that hasn't really been explored as far as I know in court. The EU, on the other hand, in its GDPR, its privacy laws has a specific provision stating that traffic management doesn't allow an ISP to check the actual contents of the packets that are being sent. Of course, that's honoured in the breach. Here's an article from ZDNet saying that at least 186 of the ISPs there actually use deep packet inspection. Next stage, over-the-top providers. So what do we regulate in New Zealand? This is for the Googles and the Facebooks. I just want to very quickly show you what we regulate in terms of managed applications, just by way of contrast. These are applications provided by the telcos themselves. Those are regulated under the Telecommunications Act. You've got, for example, the TSO deed under that act, which binds Spark. It has certain provisions in terms of how, for example, a residential voice line can only be down for about 50 minutes a year per person. And there's the 111 contact code, which requires the operator, for example, if that managed voice service is provided over broadband over a packet switch network, to make sure vulnerable people have a means of reaching 111 in the event of a power cut. Now, it's a bit different for third-party applications. The Telco Act has nothing to do with them. And in fact, it's a wide range of statutes. I've put a few down here: the GST Act, the Films, Videos and Publications Classification Act, Harmful Digital Communications Act, and Contempt of Court Act. And this was quite frustrating to me when I was in the telco team here at MB, because I wasn't really allowed to get involved in any of the regulation of these third-party applications. Just 3 quick examples. Electronic marketplaces, that's a type of third-party application. You might remember the Amazon tax issue. So it used to be that it was just too much hassle for customs and inland revenue to collect GST on goods worth less than $400. And New Zealand booksellers were quite upset, because of course that meant that they were having to charge 15% more than their offshore competition, the likes of Book Depository, for all the books we read. And in 2019, the Amazon tax came in and put a stop to that. Commercial video on demand providers are now, well, certain ones, those specified in the schedule, are now regulated under the Films, Videos and Publications Classification Act. The likes of Google and Sky and Netflix. That was really a result of a bit of an outcry over 13 reasons why. The people like Sparks, Spark had a video on demand service called Lightstream or something similar, and then they decided actually they didn't need to submit every single title to their chief censor. So for a few years after that, they were just doing their own classification. And after they botched, I think, the 13 reasons why classification, the minister at the time, Tracy Martin, decided that a new system needed to be imposed. Lastly, over-the-top providers who qualify as online content hosts are regulated under the Harmful Digital Communications Act and the Contempt of Court Act. Basically, you can, like this person, Lorna Jones, ask a court to tell online content hosts to take down or block certain material. This is where it gets interesting, and I'm conscious of the time, so I will I'll probably take another 7 or 8 minutes. Over-the-top providers, what we don't regulate for a right to be forgotten. So that was the case of Google against a chap called Gonzalez in Spain. He was a bit upset that some information about debts that he had had in the past was still available through search engine. The EU courts interpreted their privacy directive as saying that after a while, Google has to stop linking to those stories. We don't regulate local content. The EU does. It says that video on demand suppliers like Netflix have to have at least 30% local content, European content, and France goes even further and says you have to have 50%. Platform neutrality. We don't have any rules on platform neutrality. The EU does have them in terms of transparency obligations on certain over-the-top providers. They have to tell business customers if they are providing a preference to any other business customers. France has it for business and standard customers. French like to go a bit further. Data portability, the EU has a rule that applies to all sectors, saying if you want to shift from one provider to another, they have to facilitate the transfer of all your information. So if you want to go from Facebook to a competitor, Facebook has to make that happen, transfer all your posts and information. New Zealand doesn't have that. We are looking at a consumer data right, but that's going to be sector by sector. So who knows if and when the over-the-top sector will be mentioned. Accessibility, we don't have any rules on over-the-top providers about being accessible to people with disabilities. The USA surprisingly does. Data localization, we don't require any information to be held by over-the-top providers in New Zealand. Australia does in terms of health information, which they consider too sensitive to be held or processed offshore. We don't require over-the-top providers to contribute to universal service, which personally I think is something we should look at. They use the networks to reach us. Perhaps they should be chipping in. The USA does require certain voice over IP providers to contribute to their version of universal service. Fake news, we don't have any provisions that can force an over-the-top provider like Facebook to get rid of news that's considered fake. Singapore does with that famous act I mentioned before, the Protection from Online Falsehoods and Manipulation Act. And France has a version that only applies during election periods, and there's a test that the news has to be fake, but also likely to undermine the credibility of the election. And lastly, we don't have any regulation of payments for news services by over-the-top providers. You'll have heard about Australia, which has introduced a system whereby for any over-the-top providers who are listed in a schedule, they are subject to arbitration in terms of how much they pay Australian news providers to use or recycle their articles. So this is just a quick overview. I wouldn't guarantee the accuracy of this. This is just me over the last few weeks looking at different countries and trying to work out where we sit. But you'll see that green is where it's strongly regulated, yellow is where it's mildly regulated, and red is where it's unregulated. And you'll see that New Zealand really does look like a very, very lightly regulated jurisdiction in terms of over-the-top providers. Lastly, end users. The end users of those managed applications, I won't dwell on this because we're focusing on end users of third-party applications, but those end users are subject to the Telecommunications Act again. Section 112 is about sending fictitious messages, that sort of thing. And the Unsolicited Electronic Messages Act applies to in as much as you send spam by fax, which I imagine was a thing at some stage. We're more interested in these end users here. And just as before, they're governed not by a single act or two, but many acts. And we're going to have a look at some of those right now. End users of over-the-top providers. Second to, well, last page really. Here we all are, end users. One example of where they're regulated is in terms of name suppression. If you breach it, that can be a breach of the Contempt of Court Act. And the night before their name suppression ended, I was on Twitter and I found this. William Willis and Hannah Rawnsley are the Wanaka couple. So it definitely happens. And of course, Leo Malloy up in Auckland keeps on naming the Grace Millane killer. Harmful digital communications. If you post or send one of those, you can be in breach of the Harmful Digital Communications Act. I found this in the Herald since 2015 when the Act came in. About 556 people have been charged. It's about 100 a year, I suppose. But only about half of those have been convicted. And one of the problems is in the political, was highlighted by someone from the political sphere. You might remember Jake Bazant, a National Party candidate up in Auckland. He posted an intimate visual recording, but he didn't do it with the intent of harming the person in that recording. In fact, what he was doing was catfishing, pretending to be this person. So he was doing it with the intent to benefit himself. That really highlighted a flaw in the law, and change the law is going through at the moment to address that. Computer system offences, that's under the Crimes Act. They're quite topical at the moment. DDoS attacks at the moment on Kiwibank and the Met service. ANZ, my bank, I had a few trouble, a bit of a problem getting to use them recently. And then I wanted to show you this. This is a strobe light. And I've put assault down the bottom as an example of something that an end user can do. Now, there's a very interesting American case where a political commentator has epilepsy, and a person who was upset with his points of view sent him a tweet with a GIF with a strobe light in it. And that strobe light triggered an epileptic fit and led to some permanent damage to the person concerned. This was actually treated in the civil courts as a battery, but I think it could be. We couldn't do that in New Zealand, of course, because of ACC, but I think it could transfer to the idea of a criminal assault in New Zealand. The judge in the case said that there was a direct contact because the light in the strobe hit the plaintiff's retina, so you have that contact that's required for a criminal assault, and also it transformed the computer into a weapon. So he was found liable for assault with a weapon. Anyway, I thought that might be quite interesting to hear about. Lastly, you can't distribute objectionable publications because that's a breach of the Film, Videos and Publications Classification Act. And we all know that people have gotten in trouble for distributing, sharing videos of the mosque attack. So thank you for bearing with me as I ran through that. If you have any questions after today, you can reach me at this email address. You can use one of the over-the-top providers to search for telecommunications law in New Zealand if you're interested, and then you'll end up with this on your screen. So thank you for your time, and I'm happy to hand back to James.
Thank you, Robert, and thank you everyone for paying attention. Now, I've been working in this space for 6 years, and I've found this a really useful summary and a lens on things. We've got quite a few questions in the queue. I'm going to do a mixed model of using the order they came to my attention with the upvotes. That's for my convenience, but we'll get to as many as we can. And I'll permit myself a brief comment. That assault case, I think, was some of the issues were under discussion when I did a law and IT class with David Harvey in 2007 or 2008, and I wrote a paper on tort over the internet. So it's the same logic being applied there. But with that, there's quite a few questions about over the top and the end user layer, and one of them from Kay Jones is getting at and we've taken this end user's point of view, and the infrastructure players, that the people who are down the stack, can be quite powerful, even if they're not providing the connections. So some over-the-top providers like YouTube and Google can claim they're neutral providers, and they should be exempt from publisher or content responsibilities. And yet they use algorithms to actively promote some content rather than others. So should or could there be regulation requiring open algorithms or otherwise to operate this neutrally? And Kay talks about possible responses. Providers might say no, as this damages their commercial model as paid advertisers. And this is relevant for the Christchurch call and hate speech in terms of promotion of white supremacy and misinformation. So what can regulators do on that front?
So that would essentially be a platform neutrality issue. And I don't have an opinion on whether we should do it at this stage. But I would say that generally speaking in terms of over-the-top providers, I think we can do more. So this would be a candidate for doing more. I haven't seen any information about the regulation of specific algorithms, but I'd be interested in other people's views as well. If this were a live presentation, I might see a couple of hands being held up at this stage, which could rescue me from.
Well, we're living with the medium we have.
That's right.
And thank you for enabling it for those of us still in Tamaki Makaurau. So the one of the questions that's come to the top, people are most interested in, is what do you think should or shouldn't be regulated in New Zealand, taking into consideration the groups who tend to experience the most online harm? So for example, women and girls, people of color, Muslims, Maori, and Pacifica.
Well,
I know I'm putting you on the spot because this is a tough set of issues that people working on these issues, working in this space, are grappling with. Everyone agrees it's important, and there's gaps in the current system.
That's right. I think it's difficult to frame obligations on over-the-top providers in terms of protecting specific types of person. What I think you can do is, in some jurisdictions, they have an obligation on their over-the-top providers not just to reactively remove certain content, but to proactively search it out and remove it, not waiting, for example, for an order from a court. I think something along those lines would perhaps be of most help to everybody, including those communities that were mentioned.
Yeah, and there's some inherent struggles because it's those already underserved and overburdened people who know the most about this, and so at the moment they're often having to do the work to find these things and raise them for concern. From someone who is well known to both you and me, Robert, Kim Connolly-Stone, if you could change one thing about the current regulatory environment, what would it be?
I would require over-the-top providers to contribute to the country's telecommunications development fund. They, as I mentioned, they use the highways and byways that are paid for not just by the ISPs, but by, in New Zealand, the government. We've been responsible for co-funding the rollout of our excellent fibre to the home initiative. And the major beneficiaries are the likes of Google and Facebook. I really think it's, if I were somehow elected and appointed minister responsible for the Telecommunications Act, that is an area I would look in.
And I'm gonna push you on that. Do you have a preferred mechanism? So should it be a neutral tax of some kind, or is there some particular mode of service that you'd see as qualifying or being levied?
Can you just explain that a bit more, James?
Okay, no, it's probably too much detail for this point.
Okay.
I'll go to another question.
Thanks.
So Jenny Nagel says, we seem like the Wild West with no apparent obligations or responsibilities for OTT providers or ISPs. What stopped us following overseas regulations?
I would say for both categories, ISPs and over-the-top providers, New Zealand, we don't have a big population. So unlike, say, India or China, we can't just rely on these ISPs and foreign companies coming over and investing in New Zealand because they know there's a huge market to tap. So there's a sense, I think, in New Zealand that we need to be very careful before we start imposing too many obligations on ISPs and over-the-top providers. I think the situation is even more marked with over-the-top providers because unlike, say, an ISP, they really don't have any sunk costs in New Zealand. So if they want to leave because they don't like some regulation that we've introduced, they will leave, at least temporarily. I think the examples in Australia recently are quite telling. So firstly, I believe when Australia introduced its version of the Amazon tax, the Amazon shut down access to the US Amazon site for Australian users for about 6 months before finally opening it up again. And then just this year, you may remember seeing Google pilloried in the Australian press because they, what was it they did? No, it was Facebook this time. It was in this news, payment for news scenario, and they removed the ability of Australian end users to share Australian news media content.
And not just news media, that it also affected a range of community services, including government providers, not-for-profits. So yeah, the actions of Facebook there, I don't think anyone here is a huge fan of. On the other hand, I'm not sure that in New Zealand we want the equivalence of their big media companies as such a prominent political player. That seems to be some tensions there. Another question, and we're probably going to wrap up after this one. What is the link, if any, between regulation of ISPs and telcos and regulation around domain names, particularly .nz? And that's from Jeff Montgomery, one of our new council members.
Oh, you may have noticed that I didn't touch on domain name regulation or internet governance at all. And really, I think Judge Harvey is perhaps the right person to answer that question. I really am a bit of a newbie, I have to say, in terms of ISPs and over-the-top providers. Just to tell you how, I was very focused on telcos, but in 2019, I popped over for 6 months to California to teach telco law. And my students, they were just interested in ISPs and over-the-top providers. So I really had to adapt. And it was at that point that I became very interested in this area. So I'm afraid I don't have an answer to that question, but it is a good one. Okay,
and with that, I'm going to have to apologize to people whose questions we didn't get to. There's been a really good set of exchanges in the chat, and I think I certainly appreciate the chance to come along and hear from you, Robert, about this book, which must have been an immense effort to pull together. About how long did it take from start to finish to get this book together?
Well, there were a few false starts. It took a long time to get permission from my employer, but I would say it took from mid 2019 to mid 2021, really. In the end, I'm glad that I didn't get the go-ahead much earlier, because otherwise I wouldn't have included so much about internet law in it.
Okay, so definitely a substantial effort, and we're grateful to you for making yourself available for a members event. So there's been lots of interesting exchanges in the chat. I can see people reminiscing about sci-fi conventions where they've met up, and now we're living in a sci-fi world. And for the people who are saying it wasn't so interactive as many of our members events have been, this is a big topic, and today we've had the chance to have Robert come along and present on his book, and I think that's been valuable for a lot of the people here, certainly for me. That's been the focus for today, and we want to offer that to help give you a more in-depth understanding of the internet. So no one of us is the authoritative voice. We do best when we have an exchange that's true. This is the way that suited us and Robert to run this event today. What you can do, if you want to continue a conversation, is you can go on NetHub, which is InternetNZ Slack space, and that's open all the time. And we're going to have a link to that posted in the chat. And we'll also, shortly after this event wraps up, send out a survey to get feedback. And we'd welcome your ideas about other topics and other modes of engagement that can be more interactive. But for today, thank you. Ngā mihi kia koutou. Thank you everyone for coming along. Thank you, Robert, for a fantastic presentation. And to everyone, pai tō rā. Have a great day.